No, she's the chairman. I'm the first.
All right, everybody. Thank you for joining us in Coastal Remedies. We've got a riveting panel of three for you today, and there's also some folks in the audience I know who are going to have good questions because they're steeped in this stuff. First up, we'll have Lulin Petrie of Kelly Hart, who's going to give us a bit of a historical overview of coastal protection, restoration. He works for the defense, but he's not speaking for the defense today. He's really here to give us an introduction and lay some foundation. And then we'll also have Blair Schilling, who is with Fishman Haygood. She's also a colleague of mine. I'm Bessie Doshbach, by the way. I'm managing partner at Jones Swanson, Hiddell & Garrison. But we partner often with Blair and her firm on environmental litigation, including our coastal litigation. And she's going to address our efforts in the litigation on behalf of the Flood Protection Authority and also landowners and some of the cases that kind of laid some of the foundation for the work that we did and are doing in that work. And then our esteemed colleague Vic Marcello of Talbot Carmouche is going to speak to the Parish litigation. And I think that today will be an interesting exercise and giving you guys a lot to think about. But we've got it set up where folks are planning to go about 20 minutes. Questions at the end, but if something strikes you, I think anyone would welcome addressing those questions while they have the podium, since we're not actually set up as a panel today. So don't hesitate, raise your hand, and we'll get to you. Okay? So with that, Lulin, the floor is yours.
So I grew up in the good thing about speaking at law school is you can tell the same story you told 4 years ago and count on it that no one in the room was there to hear it 4 years before. I grew up in Cut-Off, Louisiana, about 20 miles inland from the coast, where my family moved after the great 1893 hurricane of Cheniere Caminada that wiped out a coastal village and drowned about 1,000 people or more. And, for about 17 years of my life, my only real source of knowledge on the outside world was the World Book Encyclopedia from 1962, which for the law students who are here, it's a book. It's 26 books, and the books don't change. It just stays 1962. So you pull out the A and you find asbestos, and it says, "This is the greatest thing ever made." And so I leave, I go to college, I go to law school, I take the bar, I come home, and one day I'm at home at lunch, and Mom made lunch, and she says, here's, look at this. And I says, well, what's this? And she says, well, your brother Glenn got this in the mail, and he's out of town, and I thought you could look at it and see if he needs to worry about it. So I open it up, and it's a notice of application for a coastal use permit. And the applicant is an oil company. And I look at it for maybe 10 seconds, which is 0.25 for those of us in law firms. And I say, you like that, Richard, don't you? And I say, the first person to take my deposition is in the room. And I say, the oil company wants a coastal use permit. They want to go do something in the back. They want to use airboats. They want to use marsh buggies. They need a coastal use permit. Glenn got this notice because he owns his property on the bayou side. And we didn't get a notice because our land is not on the bayou side. But they're not going to use marsh buggies in the bayou. And they're not going to use airboats in the bayou because it's a no-wake zone. So you can just throw it away. And Mom's ready to throw it away. And Lulin Sr., who Kathy knows, I had a few conversations with, says he's just sitting at the end of the table and he's looking really, really, really angry. And my mom says, Lulin, what's wrong? He's Lulin in that house. And says, well, I want to get that landman to come here. I want him to tell me where he's going to drill the well. I want him to tell me what the unit's going to look like and who's going to be getting royalties. And then we can think about putting this aside. And Mom, who loves all her children, said, but Lou just looked at it, and he says it's nothing for Glenn to worry about. In that house, I'm Lou. And that's when my dad said, we're going to have all of this thoroughly examined by a respectable oil and gas attorney. So, and 3 weeks ago, Ollie Hout called me, and actually it was probably about 3 days ago you called me. I probably was 5th or 6th on your list, but and you know I know what the Environmental Law Institute is. I mean, I was once in a court where I had 8 issues before the court, and Vic Marcella was on the other side of those issues, and 6 times I got up and said my piece, and Vic got up and said, Judge, Lulin's wrong, and the judge says to me, denied. And 2 times, Vic got up and said, Judge, Lulin's right, and the judge says, I'll take it under advisement. But that was better than the crowd here, right? So Ollie Hout calls me 3 days or 3 weeks ago and says, we'd like to be you to be on a panel, and we'd like you there to provide balance. And Bessie's here, brilliant, and represents plaintiffs. I don't know why that happened. Turn this off, Bessie. And Blair's here, represents plaintiffs. Vic's here, represents plaintiffs. And if I'm providing balance, I must be really good. They're good. But what I'm going to do, I told Ollie, I said, I know what you want. You want me to be there. Why do you want me to be there to provide balance? Why do you really want me to be there? And Professor Hout says, we want you to be the bad guy. And I said, I hurt my feelings. I said, my mom doesn't think I'm a bad guy. And that's when Professor Hout said, well, what about your dad? And I realized, yeah, you probably got a point. But what I'm going to try to do is talk a little bit on a very atmospheric level about what is coastal law in Louisiana, because I was speaking at a coastal law in Louisiana seminar last week, and we were talking about what is coastal law in Louisiana? Is it a discipline? Is it? I can't find a case book on it. I can't find a treatise on it. I said that last week, and one of the other panelists came and said, "Oh yeah, we can write it." That's great. It's not what I was looking for, but thank you. I want to give a historical perspective, very atmospheric, because I got 20 minutes, on where coastal law came from, and then I'm going to slow down a little bit to talk about the last 10 or 15 years, and slow down a little bit to talk about the last 5 years, which will get us to some version of the present, and have these people talk about predicting the future, which I'm not going to do. I'm only going to predict the past as best I can. I'm not going to predict the future, and I'm going to try not to have any opinions. And if I have them, they're just mine. They're not the industry, because I don't know what that is. So we have in Louisiana law coming back from the civil code. Civil code that were first promulgated in Louisiana shortly before Louisiana became a state, and was based to a great extent on the French Civil Code, what people call the Napoleonic Civil Code, which was based to a lesser extent on the Institutes of Justinian that go back about 1,000 years more, and set up things like who owns what and who can do what on the banks of rivers, and Kathy, who can do what on the seashore. And the civil code that's in effect today, that was put in effect in 1979, says you have a right to shelter yourself and to clear nets, clean your nets, which is very important, on the seashore. It also does not say in the 1975 version you have was the law until 1979 in Louisiana. Everyone, the words are everyone, that's two words, everyone had the right to build cabins on the seashore, to build cabins. And it still says you can take shelter, so maybe you can still go build a cabin on the seashore, but until 79 it specifically said, every one of you, even if you're not from Louisiana, you could build a cabin on the seashore. But, you know, what's the seashore? What's the seashore? And Kathy and I had a little tussle about this a few years ago, but the seashore is defined as what's between the public sea and the place where the high tide goes in the winter. So where is that? It might not be the same every year. In fact, it's almost certainly not the same every year. And if there's erosion or there's building a new beach, it's not the same. And if water is getting higher, or getting lower, or whatever, it's going to move. And to make it even more fun, I told you, this all goes back to Justinian. This language, if you read it, sounds very much like Justinian. And that was written for the Mediterranean. And according to Professor Ianopoulos, and I don't know if he's right about the science, but Professor Ianopoulos has a passage in his treatise where he says, guess what? In the Mediterranean, the highest tide in the winter is the highest tide of the year. But in the Gulf, it's the opposite. So maybe, Kathy, there's not very much seashore that you might have to be one of those tiny houses when you build that. So you got this civil code, European, Roman even inheritance that's on top of all the issues about ownership and use on the coast. And some of it's confusing, and some of it's hard to understand, and some of it, frankly, sounds a little archaic when you read it, even if it was updated in 79. Then you start having this federal overlay of federal statutes, and you have the Submerged Land Act in the 1840s and 1850s that took submerged land acts that were in the federal domain, put them into the state domain, and allowed the state to sell them if they were going to drain them for agricultural purposes. Okay, just listen. In 1850, they thought draining something for agricultural purposes was just a great thing. So great that you should give people land if they promised to do it. Then in 1890s, we had the Rivers and Harbors Act that set up protection for federal navigation works. In 1928, after the Great Flood, we had the Flood Control Act that led to the levying, the major levying of the Mississippi River. And then in 1970s, we had all of the major national environmental legislation that I'm sure all of you know well, and which I'll submit was not written thinking about the problems in Louisiana that we're facing today in the 70s. And I'll also submit that the Institutes of Justinian were not written in about 700 thinking about the kind of problems in Louisiana that we're facing today. Then in the 70s and starting in the 80s, and Mark, you can probably correct me on the details, but there started becoming an awareness that we're not just gaining land in Louisiana, and we're not just worried about flooding in Louisiana, but we're starting to lose land in Louisiana. And I'm speaking very generally because I know you all want to hear about the allegations in the litigation, and I'm not going to tell you yet. But we have, starting in 1990, the state of Louisiana setting up a structure, an authority to try to deal with coastal restoration. And we have, starting in that same time period, what people call the BRO Act or QIPRA, setting up for the first time, a federal funding source for coastal restoration, which has been followed by two other funding sources, Mesa and restore in the last 10 years or so. And we have in 2005 Hurricanes Katrina and Rita, which followed by the state setting up the Coastal Protection and Restoration Authority, trying to merge a lot of levee districts. In fact, the original legislation was there was going to be one levee district created out of the 20-something in the state. I think there are maybe about 18 now. So they were consolidated at some level, but mostly in the New Orleans area. And the Coastal Protection and Restoration Authority was an effort to consolidate and combine and create some dialogue between environmental restoration, wetlands restoration, and I'm going to try to wrap it up, and flood protection. Because before that, they'd been totally separate. One agency's building levees, and one agency's trying to restore wetlands, and they're not even necessarily talking to each other that much. And as the heads of the agency said at the thing I was at last week, they would, the secretary of one agency would go to Washington and meet with one of the congressional delegation, and would be walking out of the room and meet the secretary of the other agency walking in, both asking for money to do things that might seem to be somewhat related without any coordination in the plans. But that came to the concept of the master plan. The master plan, which started under another name in the 90s, but really, when we talk about the master plan for coastal restoration and protection in Louisiana, started with this legislation in 2006, following the hurricanes of 2005. And that leads us up till today, and that's all that overlay goes into what has been happening. I can do it in 5 minutes. In the oil and gas industry, starting 15 years ago, there was a major uptick in landowners suing oil and gas companies for environmental damage to their property. There were a few reasons to that, and probably all of these people will take maybe not you, you're not old enough, but take credit for figuring out how to do it. But that became a big thing. But then 2013, we had two big things happen. In about the spring, the South Louisiana Flood Protection Authority East, which was one of the agencies that was consolidated in that legislation in 2006, filed a lawsuit against 97 oil and gas companies and essentially alleged that the dredging work done by pipelines and oil and gas companies in the wetlands south and east of New Orleans had made it more cumbersome and more expensive to protect New Orleans from flooding, and that gave rise to a legal claim. That case, as most of you probably know, was removed to federal court. The federal court denied a motion to remand and then dismissed the claim on a very broadly on the basis that the claim had too many steps and was too tenuous to state a cause of action in law, which was affirmed by the Fifth Circuit, and writs were denied by the U.S. Supreme Court. And that case, with a capital C, is done. In October of 2013, right, Vic?
December.
No. It was October.
We were removed.
I remember where I was. In October, yes, you were removed in December. In October, the parishes of Plaquemines and Jefferson filed. I'm going to take 5.
Great.
Someone showed me a 3. Where's your card? Did Ollie Howe tell you to put that up there? In 20 cases filed by the parish of Plaquemines, and about 8 filed by the parish of Jefferson on the same or 2 subsequent days, allege a very different kind of claim, but really arising from the same claim activities and alleging the same alleged damages. But in those cases, the parish said, we are suing as a regulator. And the way I explain it to people who are not lawyers is the Flood Protection Authority suit was, Don Price, you ran the red light, you crashed into me, I'm injured, and I'm suing you to compensate me for my injury. The parish suits are the state trooper showing up and saying, you read the red light and we're giving you a ticket. The parish suits allege that the parishes are, on behalf of the state and pursuant to authority the parishes claim to have, enforcing the coastal zone management law and regulations of the state of Louisiana. Not saying you caused me damage in a tort-ish kind of way, but you were speeding. You didn't do what your permit said, or you didn't get the permit you were supposed to do. Since then, a few things have happened. One, that 28 has turned into about 42, including the parishes of Cameron, including the parish of Vermilion, although that one's a little different, including the parish of St. Bernard. Any other parish? St. John the Baptist. St. John the Baptist is the newest one. Yeah. And about 40 of them, all of them were remanded, but Vic put in a famous paragraph 34.
33 in some cases.
In paragraph 33, Vic asserted that he was not bringing a federal claim in so many subparagraphs that he almost ran out of the alphabet. The letter, he got the U or V or W with the subparagraph. I'm not doing this, I'm not doing this, I'm not doing this. And every single one of those cases in which a motion of remand has been ruled upon has been remanded. And the ones in Cameron, there hasn't been a ruling, but there's been a magistrate's report and recommendation recommending they be remanded. And you may remember the old governor, he wasn't old, I guess, but the former governor, the immediately preceding governor, was not a big fan of any of this. And the state generally, and I hope no one will challenge me, that the newer governor is perhaps more of a fan of this than the previous governor. And the Department of Natural Resources has intervened in support of this litigation. The Attorney General has intervened in the litigation. I didn't say support that time. But and
Very cool.
And five of the cases in Plaquemine have been set. I've been told to stop and I'm close. 5 of the cases in Plaquemine have been set for trial in 2019. And that's where I'll stop.
Very balanced.
Hi, everyone. I'm Blair Schilling, and like you've already been told, I'm wearing the white hat today. So I represent plaintiffs, landowners against oil and gas companies for contamination and land loss across the state of Louisiana. And I'm going to do a little bit more of a narrow focus, but hit on some of the same points that we've already talked about. My presentation is going to be about the evolution of the duty to maintain pipeline canals in the state of Louisiana. And this is important for several reasons. If there is no duty to maintain these canals, then it's going to be very difficult for us to restore Louisiana's coastline. And as the first slide shows, and as many of you probably know, Louisiana is losing ground very quickly. This is some photography taken from a UNO study that shows the land loss that has occurred between 1993 and that's projected by 2020, and it's pretty scary. Sorry, one second. So this is also another study that was done that will show land loss by 2099, and these are the Louisiana cities that could be lost due to the land loss. And one fact that people often quote is that Louisiana is losing 1 football field of land on average per hour. So this slide shows that the wetlands are our first line of defense against coastal land loss and against hurricane flooding, and they serve as our buffer. So the gray box shows several studies that have confirmed this. One says the saltwater marsh is an important hurricane buffer. Another, the marsh serves to protect man from the severity of storms by acting as a buffer. So this shows how important our wetlands are, and that it's imperative that we restore them. There have been a multitude of studies that have concluded that the oil and gas activities have contributed to land loss. This is just a few, and as you can see, it includes research done by the Army Corps of Engineers, the Louisiana Department of Natural Resources, the U.S. Environmental Protection Agency, and these surveys were done as early as 1971. And it's not just regulatory and government agencies that have said that the oil and gas industry is hurting Louisiana's coast. It's also the oil and gas industry. This is an affidavit by a former Shell executive in a case in California where he says, there is clear evidence that past and current oil and gas activities have made and continue to make substantial contributions to degradation in the natural defenses against hurricane surge and waves in coastal Louisiana. All these works and activities have contributed significantly to the loss of natural defenses such as barrier beaches, wetlands, and marshes. In several important cases, it was the loss of these natural defenses that contributed to the unanticipated breaches of flood protection facilities. This is a map of Louisiana pipelines, and as you can see, in South Louisiana, there are a lot of oil and gas pipelines. There is about 10,000 miles of Louisiana pipelines in South Louisiana. So this is important because the canals that most of these pipelines sit in are the reason for a lot of the land loss. And so you can see how crosshatched this is, and over the portion of South Louisiana that we're losing the most quickly. One other thing that I think that we should note is that there's several documents that show that the industry had knowledge that their canals were causing land loss in Louisiana. This one is particularly important because this one was commissioned by two oil and gas companies, Tennessee Gas Pipeline Company and Southern Natural Gas Pipeline Company. And it concluded land loss due to canaling is a matter of serious concern in Louisiana in 1972. So the next thing I'm going to do is I'm going to talk about some cases. We're going to talk about 3 different cases, and they have 3 different concepts of duty. The first is Barisic versus Columbia Gulf Transmission Company. The next is what most people refer to as the levee board case or the SLFPAE lawsuit, which I think you all have just heard a little bit about. And the last is Vintage Assets versus Tennessee Gas Pipeline Company that my law firm and Bessie's law firm just tried in September, and that is a landowner case. So I'm going to start with Barisic because it is the oldest. This case was filed in 2006, a little less than a year after Hurricane Katrina. And this case included an indefinite number of private plaintiffs with widely differing damages. The plaintiffs were, who sustained injuries were from 17 parishes. It also included an indefinite number of defendants for unspecified activities. It had a pipeline class and an exploration and production class that were separately filed, and then the court consolidated the 2 into one case. So it was a very large, sprawling case. Among other things, the plaintiffs claimed that the defendants were negligent under Civil Code Article 2315, which is the negligence article that everyone, I'm sure, is familiar with. It's important to note that there was no privity of contract with the parties in this case. So the court, to determine whether there was a duty here, needed to go through a duty risk analysis like you do in any negligence case. And in Louisiana law, you have to determine whether there's an ease of association between the defendant's conduct and the plaintiff's damages. And when the court went through that reasoning here, it said that the plaintiff's claims were too attenuated, and so there was no duty. And this was for three main reasons. There was no privity of contract between the parties. The plaintiff sued for hurricane damage for storm surge that was, quote, allegedly magnified by coastal erosion caused by canals, not for direct land loss to acreage due to erosion. And there was no statutory basis to imply the duty from. So the court concluded, for plaintiffs to recover in this matter, they must demonstrate as a matter of law that defendants had a duty to these hundreds of thousands of plaintiffs to protect them from the results of coastal erosion allegedly caused by operators that are physically and proximately remote from plaintiffs or their property. So that's important language because it says that you can't be physically far away from the defendant's activities and that this is too many plaintiffs. And so that was interesting to our side because it said this case is just too big. But what Barisic also said was that under different facts, maybe a duty could arise. The court said, by all accounts, coastal erosion is a serious problem in South Louisiana. If plaintiffs are right about the defendant's contribution to this development, perhaps a more focused, less ambitious lawsuit between parties who are proximate in time and space with less attenuated connection between the defendant's conduct and the plaintiff's losses would be the way to test this theory. So in 2013, the SLFPAE lawsuit was filed, and it was intended to test this theory in some ways. And so it was filed in July of 2013. It was removed to federal court then by the defendants. There was several causes of action including negligence again. This will show you that SLFPAE, it's a flood protection authority, and this shows you the map of the areas that it's authority over: the East Jefferson Levee District, the Orleans Levee District, and Lake Bourne Basin Levee District. This lawsuit, as opposed to Barisic, had one public plaintiff with one charge, flood protection, and it also had a definite number of defendants that were identified by well, pipeline, permit, and right-of-way agreement. And as you can see, there are 97. There are a lot of defendants here, but it's still different from Barisic because all of those defendants were sued because they had some sort of conduct on the levee authority's property. So this map will show you the geographic distinction between Barisic and SLFPAE and why this was intended to be the less ambitious lawsuit, although it was still very ambitious. The white area is the area that Barisic suggested, and then the colored regions to the right are the areas that the SLFPAE lawsuit covered, which is just Orleans, East Jefferson, and Lake Bourne Basin. The other thing that was important from Barisic is that the court said that there wasn't a duty because there was no statutory authority to imply a duty from. So in the SLFPAE lawsuit, we argued that the duty could be implied from several statutory regimes, including the Rivers and Harbors Act, the Clean Water Act, and the Coastal Zone Management Act. We also argued that a duty could be implied from the Louisiana Coastal Zone regulations, which require mitigation of erosion. But unfortunately, the district court, unfortunately for me, maybe not for everybody in the room, the district court dismissed the lawsuit. The district court did not engage in a specific ease of association analysis to determine whether there was a duty in this case. Instead, the court said that Barisic was a per se rule that oil and gas companies do not owe a duty. And I quote, "This court has already opined that oil and gas companies do not have a duty under Louisiana law to protect members of the public from the results of coastal erosion allegedly caused by pipeline operators that were physically and proximately remote from plaintiffs in the property." So the court disagreed and thought this was still too ambitious of a case, and that, or maybe the court didn't look at the language in Barisic that suggested a less ambitious case could have a duty. It's hard to tell. The Fifth Circuit, we filed an appeal, and the Fifth Circuit affirmed the dismissal and said that the Louisiana's duty analysis, the federal statutes were not created for the purpose of giving this plaintiff this harm that was alleged, and so we couldn't imply a duty from those statutes. So this moves forward to Vintage Assets, which was a private landowner case. This is the one that I told you earlier. We tried this last September. And this case, we learned a lot from Parish, from the SLFPAE lawsuit. So this one was a very narrow focused case. It was a claim by a group of landowners against two pipeline companies for pipelines that were present on the plaintiff's property. We brought claims for negligence and breach of contract. There was a couple of other claims as well, but those are the important ones for today. The damage was for loss of land on plaintiff's property by conduct that was on plaintiff's property, and there was a privity of contract between the parties. There was actually 7 right-of-way agreements at issue in this case. So when the court ultimately decided that there was a duty to maintain the pipeline canals, in the process of doing that, the court determined that there was internal inconsistencies in the contracts themselves because they allowed the pipeline canals to remain open, meaning that they were not required to be backfilled, but that also they had to keep the canals within a certain boundary. And in this case, it was either 40 feet or 65 feet per the contractual language. And so because of that conflict, the court ruled that the parties had not considered erosion damage when they had entered into these contracts, and so we had to look to Louisiana's suppletive law to fill in the gaps. And so the court says, it is well settled that Louisiana's suppletive law on servitudes impose a continuing duty to refrain from injuring or aggravating a servient estate. The servient estate was the plaintiff's land. The question of first impression before this court then becomes whether the duty to refrain from aggravating the servient estate encompasses a duty to maintain canals and canal banks from eroding the servient estate. This court finds that it is self-evident that allowing a canal to widen such that it encroaches on the servient estate or erodes the servient estate into open water constitute aggravation. Accordingly, pursuant to the suppletive law, defendants have a duty to maintain the canals and canal banks to prevent erosion and therefore aggravation of the servient estate. So the most important thing is there at the end that they do have a duty to maintain the canals, and they have a duty to maintain the canals within the boundaries that the contracts provided, 40 feet or 65 feet. And we had lots of expert testimony that said that these canals had widened to 100 plus feet. So the court was not as helpful to us on our tort claims. However, the court dismissed our tort claims and said plaintiff's allegations in tort is that defendants were negligent in failing to maintain canals and preventing them from widening. Accordingly, plaintiffs allege that defendants failed to perform an obligation in their contract, the duty to maintain, which constitutes a passive breach of contract. They do not allege that plaintiffs negligently maintained the canals. Pursuant to Louisiana law, such a breach does not give rise to a tort claim. So here, the court said because we said that they failed to do something as opposed to failed to do something well, that there was no tort claim because that was a passive breach as opposed to an active breach. So what does this all mean? If you ask me, and I think most plaintiffs' lawyers, you would say that this means that Parish doesn't create a default rule that there's no duty. That what the court should do is they should look to all of the factors that Vintage looked at, which was the contractual, legal, and regulatory authority that you could impose a duty from, whether the damage was foreseeable to these defendants, and the plaintiff's position vis-a-vis the defendants, meaning did the defendants put canals on these plaintiffs' property? Did they dredge canals on these plaintiffs' property? And was there land loss on these plaintiffs' property that was a result of that dredging? And so now we concluded the trial at the end of September, and we are still waiting to hear back from the judge for a final ruling. And I assume that regardless of the ruling, the Fifth Circuit will then speak on this same issue. So there will definitely be more to come. But at least for the plaintiffs right now, it seems like things are heading in the right direction, and the oil and gas industry they do have a duty to maintain their pipeline canals if there is a contract that is in place that requires them to do that. Thank you very much.
You got the rest of the time, babe.
30.
No, just leave some time for questions.
Oh, obviously. My name is Victor Marcello. I'm with Talbot, Carmouche, and Marcello. Not a really nice word, not nice name in some quarters of the oil industry, but here we are. We filed the original Parish coastal suits, and I'll give you a little bit of history on that as to how we came to file it. But I want to first start with basically the history of the Coastal Zone Management Act. As you know, in 1972, the federal government Congress passed the Federal Coastal Zone Management Act, and the purpose was to give more authority to the states in order to regulate the coastal zones, because they thought the states would be in a better position because the coast is different and the issues are different from state to state. Louisiana really wanted to get involved at the time because there was money involved, and they said, we want to get the money out of the Coastal Zone Management Act. They didn't necessarily want to use it for the coastal zone, but they wanted the money. So in 1977, the legislature passed an act, and what happens is, if you want to be in the coastal, if you want to approve coastal program, Congress, the NOAA, the National Oceanographic Administration, has to approve it. The Department of Commerce has to approve it. 77, they passed the act. The act really was a mishmash. It didn't do very much, and it didn't get approved. But the people in Chack Bay needed their fire stations, so they came back the next year, and they did pass an act. But as you all know, from some of you have lived in Louisiana all your lives, the hand of the oil industry was behind it, and we're actually living with some of the effects today. It passed in 78, and then there was a 2-year period of implementation, and it finally, the regulatory scheme finally got off the ground in 1980. The regulations we have in Louisiana are probably the most detailed and extensive set of coastal regulations in the country. They were developed out of the Sea Grant College at LSU. You remember Paul Tomplay. Paul Tomplay was the head of a group of 4 or 5 scientists that spent a whole year writing these regulations. And the regulations had to take into account the effects of basically all of the uses of the coastal zone, be it private uses for camps, homes, and the main use was for oil and gas exploration and production activity. As most of you who do some regulatory work know, that the way you develop regulations is that you develop the regulations, they're published, and there's public hearings, and then there's a hearing before the legislature, and then the regulations are finally approved. Well, for some strange reason, for some really obvious reason, in Louisiana, the coastal zone regulations were put in the Department of Transportation. The transcripts of those hearings are not to be found, despite my many public FOIA requests. I could not. They're gone. They have disappeared. But what happened is they developed. Paul finished the draft of the regulations. They were going to publish them, and George Fisher, who's the head of the Department of Transportation, said at the time, no, you can't publish them. We have to let the oil boys look at them before we can publish them. And Paul said, no. Paul was the head of DEQ under Romer, the 4 years where we actually had, until now, where we actually had aggressive environmental regulation in Louisiana. And so Paul said, no, you got to publish them. and Fisher refused to publish them, so Paul resigned, and got on a plane. I think he was a little scared to stay here. He got on a plane and he went to American Samoa to develop their coastal management program, and he's the only person in the country that's developed 2 states' coastal management programs. But as a result, the regulations were watered down somewhat, but after Paul left, but there's still basically a strong set of regulations. The program went into effect in 1980, and there are some, there's the statute and then there's the regulations, which are quite extensive. And lying in plain sight, or hiding in plain sight in the statute for all these years, has been a section that no one has ever thought to use. It's 214.36, for Title 49. And this was what we ran across doing legacy, because we were pretty heavily involved in legacy litigation, and we came across this in our legacy cases. We started doing legacy in the mid-90s. And the statute says the Secretary, the Attorney General, an appropriate district attorney, or a local government with an approved program, that means parishes, with approved coastal management programs, may bring such injunctive, declaratory, and other actions as are necessary to ensure that no uses are made of the coastal zone for which a coastal use permit has not been issued, or uses that violate an issued coastal use permit. And then here's the kicker, the next section. A court may impose civil liability and assess damages. There's no regulation. I've looked, and I've talked to lawyers in other states. I've looked. There is no regulatory scheme in the United States where the government is given a right to just sue for damages. I've never seen one. Assess damages, order where feasible and practicable the payment of restoration costs, require where feasible and practicable restoration of areas disturbed, and otherwise impose reasonable and proper sanctions. And it goes on and on and on. It just basically throws the book at anybody who violates. And this is the basis of what has been called the parish coastal claims. Now, so we were able to successfully convince 2 parishes to pursue these claims initially. The parish council in Plaquemine very bravely stepped up, so did the parish, so did the Jefferson Parish Council, and they decided to file suit as a parish. And our theory was this. Our theory was that each one of those entities, the Attorney General, Buddy Caldwell, you know, we started this, Buddy Caldwell wasn't going to file a suit, so he's out. The Secretary of Department of Natural Resources, that was Jindal, he's out. He wasn't going to file anything. And then the parishes and local district attorneys were the only 2 places you could go to get someone who would say, we're going to enforce this rule. This statute was never used from 1978 when it was passed until we filed it in 2013, not one time. And I say one thing, I have to thank the SLFPAE case for 2 things. First of all, the SLFPAE case got removed before our cases were removed. And I had basically a checklist from the SLFPAE removals of what I didn't want to plead. And that's where all of the, and by the way, he did a bad job as a bad guy because the bad guys don't tell jokes, I can tell you that. The ones I've been dealing with, they don't smile even, okay? So where was I? I'm lost where I was. But basically I had, you know, it's like a bombing map, okay? You know, this is how you stay out of federal court. So at the time, so the removal theories were basically Outer Continental Shelf Lands Act, also known as the hip bone is connected to the leg bone. If you got a pipeline that comes offshore, it goes to New York, it's all federal, according to the oil companies. Admiralty, because there was a new Admiralty case out of Texas, which basically says that the Venue Clarification Act passed 3 years ago, or 5 years ago, I think it is by now, that the Venue Clarification Act allowed removal of anything in admiralty. And then diversity. And there's another one called federal enclave jurisdiction, which we had. And boy, if you want to really drive yourself crazy, read those cases, okay? But I advise you not to do it. Anyway, when we filed the initial 2 suits, we had to group the suits into what we call operational areas. And the reason we had to do that was because we were filing for the parish, and we were filing for the parish. Basically, the parish was, I tried to fashion the parish as a relator, basically. So we styled the suits. The plaintiffs were the parish of Plaquemines and the state of Louisiana, ex-rel parish of Plaquemines. That's how they were styled because, as you all know, the argument that a state cannot be a citizen of itself for diversity purposes, so that's how we managed to make that argument. When we filed the later parish suits, we didn't have to worry about it because the state was intervening. We just tell them when we were going to file, they would intervene. The state was already in the suit. It would be aligned as a plaintiff and couldn't be removed. So we managed to hop over all these theories. We got, we ended up beating diversity. In the seminal case was the Total case decided by Judge Zaney. We were very lucky to get a good middle-of-the-road judge who looked at the issues for what they were and remanded the case for where it should be. I think it's no secret, and I don't mind even saying it in public, that the Fifth Circuit is where all good cases go to die. And we didn't want to go to die there. Okay. So now, except for the parish of Cameron, we're back in state court, I think, as to all the cases. Is that right, Donald? Donald here represents the state now. And so, and we're very interested in Cameron because one of the main defenses is going to be the court did it. That's going to be whether, and that defense plays probably somewhat, a little bit, in Plaquemines. In Cameron, there's no such thing. You know, you can't play that game in Cameron. You can actually get aerial photography in Cameron, and you can see an oil field and just take it, you know, do serial photography over time, and it's just open water after that. And there's no levees, there's no rivers, and the case is very, very, it's much more simple to prove. So I'm just trying to, I'm kind of skipping around, I realize. We have four or five cases, I think, set for trial in Plaquemines. It's five, right? And that was the subject of quite a negotiation, but we've got 5 set for trial. We're on the cusp of close to getting the Cameron cases remanded, and we're going to prioritize those. But in all, this is not just as simple as filing a lawsuit for a private landowner, because a private landowner comes to you and wants to file suit, and he wants to file suit, and generally they don't change their mind. As you all know, in Plaquemines, you know, the Plaquemines, the Madera group in Plaquemines was kind of incited by the Exxon and fellow travelers to convince the parish, the council in Plaquemines, to dismiss the case after we had spent 3 years in federal court getting it removed, getting all 21 cases removed. And luckily, John Bell Edwards was elected governor, and they had actually did pass a resolution to dismiss the case. And Governor Edwards said, if you dismiss it, I'm going to take it over and pursue it. So they decided the better part of valor was not to do that. And so that has not happened. But still, politically, it's a big fight. We had a major hearing in the legislature about the parish lawsuits, about the evils of the parish lawsuits. Donald was there. People testified, and if if you do legacy litigation or if you do coastal litigation, you need to have in your firm lawyers, you need to have contacts with good scientists, and you definitely need public relations people and lobbyists, and lots of lobbyists.
Maybe therapists too.
And yeah, well, I always have one of those. I'm over time.
No, you're doing fine.
Okay, so there was this hearing in the legislature, and Donald was there, and if you're for legacy lawsuits or if you're for coastal lawsuits, be prepared. You can actually come in the afternoon because you won't ever get up before the afternoon. You will sit there all day. It was 10 hours before we got, and then it wasn't. There was. I don't think that the legislature was in session at the time because usually what happens in legacy is, oh, we got to go into session. Sorry, we can't hear from you. Okay, but with this, and so we got up and we put on a slide presentation, and they were beating and they beat up on all of the people who were pro lawsuit to that point. And after that slide presentation was over, showing some of what you saw earlier today, I don't think there was one or two questions. It was just silence. And we haven't heard from them since. Now, I think probably that's part of that is that we have a governor now and a state government that's supporting the litigation. We're all in, but you know, it's everywhere. There's an article published, just came on my Westlaw Alert this weekend. There's two articles actually published in the LSU. It's my alma mater here. I'm gonna have to diss them a little bit, but there's something called the LSU. What is it? Energy Law Center. LSU Energy Law Center, also known as the Exxon Law Center. and one of the articles is very poorly written, but it's like totally. No, and I'd say that actually seriously. It is very poorly written. But what the article does is it basically it tries to explain what's going on, and they're coming up with issues of this is a regulatory statute, and there's no prescription. It's a big long discussion of prescription, so you can see the hand of the oil industry behind what's going on there. I'm going to complain about it, but I can't do it now. I guess this is the wrong place to complain. This is such a comfortable place to have. I do one of these in the University of Oregon. If you think it's liberal here, go to the University of Oregon. Okay. I mean, talk about, they have some theories of liability that they'll sue God over there. And and then I did one with Kelly Becker, who is a very fine lawyer at LISCO, who's doing most of the writing in the coastal suits. We did one at the Mineral Law Institute, never a friendly place for somebody like myself, last year. And so we're exchanging drafts, and finally she says, well, my clients told me I really can't get into too much controversy here. I can't say a lot about what our positions are. So we basically said, we wasted a whole hour of the Mineral Law Institute talking about removal issues, which has nothing to do with it. So if anybody has any questions, I'm glad to talk about it. I will say, though, I predicted that if we ever get out of this, if we ever get out of federal court, and we're just about there, this is the one best chance to get a lot of money to restore the coast. And we don't have to actually get it paid all up front, but this statute is so strong and it's so clear, and the violations are so open and shut. And you know, I know there's defenses. There's defenses about, oh, we started uses of the coastal zone before the statute went into effect, but these things could be limited. And this, I think we have an extraordinary chance here to do something for the coast and to put us on the right path. So, that's it.
Do you have any questions for our panel? Okay, just kind of move in this direction.
So my question is about when John Bell Edwards, if he leaves the governor's office, what implications will that have on sustaining the suits that are still progressing? And because I suspect that if he leaves and then the support falls from the parishes, is that how it works?
Yeah,
Then
well,
eventually the rest of the suits will not be able to continue?
No, this is what the issues will be when that happens. First of all, I think we're too far down the line, and that anyone who got elected governor would get a lot of pushback to just say, stop the lawsuits now. We're way down the line right now. So I'm not too worried about that. But the one thing, this was the central issue that was the biggest victory in the case that got this thing going. Judge Zaney ruled that a parish can sue on behalf of the state for violations of state permits, state-issued permits, not parish-issued. There's two coasts. There's a dual permitting system. The parishes issue what's called local use permits. Well, all oil and gas permits are state-concerned permits. So it says the parishes can sue on behalf of the state. And so like Jefferson Parish is a parish where it's very diversified. You don't have that concentration of oil industry you do in Plaquemines. Some of these cases are going to get to trial. And once they get to trial, and if we can win a couple, it's going to be a long, slow death rattle after that for the oil industry unless they wake up and try to do something. So I don't think that it was very important. It was at a pivotal time that John Bell got elected and said, no, I'm not, it's too much invested in this. And he really wants to try, as you remember from the early meetings when he was elected, he said, he brought in the oil guys and said, I'm here, open for business. If y'all want to talk about settling this case, come talk to me. There's been a lot of talk about that.
Absolutely. The other part of that maybe isn't coming through, but we should emphasize, is that the work that Vic is doing on these parish cases is critical. The work that we're doing is private landowner cases too, and so those are going to proceed. Private rights are going to proceed regardless. We face, every couple sessions, Vic's firm and our firms work together in the legislature, as he described. There is an effort to create more structure, procedural structure. We would say to make it harder for these private landowner cases to proceed, but we keep pressing forward. And as Blair explained, the decision that comes out of this vintage case is going to be a real marker for, I think, landowner cases with respect to pipeline companies going forward as well. So I think Ali had a question on the board this way.
Well, please, go ahead.
Mark?
Is this on the record?
Yes, all of it. So, is anybody sitting down and putting together a strategy for settlement talks?
Yeah, I can't talk about that.
And what would those look like in the context of the participants? Would CPRA be a part of that process?
Well, they passed it's in 214.360. That's the anti-slip provision. It says something about that. It was actually anti-slip provision that actually helped us, but that's a deep discussion, legal discussion.
We need a whole other hour for that.
Yeah, you need but yes, any monies that come out of this has to be used consistent with the master plan, the coastal master. And integrated, the terminology is integrated coastal protection. So all of the stakeholders are going to be at the table, and that's really one of the main reasons the parishes want to stay in the litigation is that, they want to get as much as they can for their vote. How that settlement will look, I will tell you there's been a lot of thought given to it. There's a lot of concepts out there, but I'm not at liberty to talk about it right now. Yeah.
So if it has to be consistent with the master plan, does that mean that it only can cover projects that are in the coastal master plan?
No, it just has to be consistent with the goals of the master plan. And obviously, there's not enough projects developed to even touch what needs to be done. So we're in the early stages. This is, you know, this is litigation against big oil. You got to climb the hill. You know, that's the way it goes. I'm sorry. But, yes.
Vic, is there any, maybe I should ask others, is there any assurance in the private suits that money recovered will be used to restore the property?
No, and I think that's going to be it. There is, as you all know, well, there's two things. First of all, you have the 30:29, which deals with oil and gas sites, and basically oil and gas. The 30, it's Act 312, what we call Act 312, only covers contamination that it's consistent with the now waste exemption, the non-hazardous oil field waste exemption. Okay. There's the Groundwater Act, but this, you know, that doesn't cover all of what we're talking about, and I expect that maybe before it's over there'll be some legislation on that. If you go back and look at the journal articles when around the time that it's a lot in the LSU Law Review, and very good articles, not like that energy thing, but there's a lot of there's going to be a lot of issues. First of all, you have issues about access, expropriation rights, those sorts of things, private landowner rights there. And, you know, those of us who do legacy, to, you know, be quite honest, there's always a tension about where does the money go? Does it go to the landowner? You know, under Act 312, enough of it has to be spent on remediation to comply with regulations. But there's really it's nothing. You know, I expect that what will happen is there'll be some legislation or some fix to make sure that all of this money goes in, whether it's generated through private funds or not. You know, private landowners have other rights other than remediation.
Vic, that structure of Act 312, I mean, internally, of course, in our practice, on legacy practice, not only are we used to the Act 312 structure, both coming out of judgments, but also in resolution, that a component of resolution, amicable resolution, is always that the operator has to go to DNR and participate in a remediation and a restoration for the contamination. And, you know, so I also would not be surprised to see something like that built out to apply to land loss with respect to private landowners' claims for land loss. We are, in our legacy cases, land loss is starting to play a role in those cases too, so I think all the more reason that we might see a structure come out that's going to try to capture that. But I also think that as representing landowners, Blair and I in this trial that we just had, every single one of our plaintiff landowners took the stand and said, we want you to fix it. That is what they were seeking. That is what we're hoping the judgment is going to say, is go out there and fix it, put it back. And that's exactly what they asked for in their pleadings, and that's exactly what they asked for in their testimony.
Yeah, we asked for a mandatory injunction where we would be required to go out and restore the property in the vintage case.
And the support for specific performance being the preferred remedy for breach of a lease or breach of a servitude should be the same thing.
I mean, you will have under, you know, Article 1986 of Louisiana Civil Code, there's this question of, you know, is it practical for there to be specific performance if you're going to end up with a court having to administer it? I mean, I don't really know how that's going to shake out. I can just tell you that our landowners have said what we want is the property back. Yes?
Two questions about vintage assets. First, when do you expect Judge Milato's ruling?
Already,
Yeah.
so long ago.
Every day.
We've got a lot going on, but we wake up every day. This is the day, and then it's not the day. So.
And my real question, I guess, how do you see? So, in one of her opinions, there's this motion to like limit damages to what was foreseeable at the time of the contract. How do you see that affecting damages in these types of cases where bad faith isn't alleged or isn't proven? And how did you argue that she should calculate damages in this case other than the injunction, which may or may not be granted?
So we fought the issue of bad faith, and we fought that actually, first of all, taken the position that we did allege facts that supported bad faith, and we briefed that to her. And part of what we put on at trial was our evidence of foreseeability. Evidence that you saw the 1972 study that Blair put up, the Battelle study, and that was in that study, for example, it was retrospective 50 years, that there was an understanding from 50 years prior that this land loss would occur if certain restoration efforts or mitigation efforts weren't undertaken. We also had a little bit of a sexy part of the case was the weekend before we had a discovery fight, 7 a.m. conference call with the magistrate. Actually, we started trial on Friday, and the conference call with the magistrate was on Saturday morning to get a video that Tennessee Gas had put together as promotional material dating back to the 50s for a pipeline they put down, the Muskrat line, not far from the line that was at issue in our property, in which they promoted all the things that they were doing on that line to prevent erosion. So we had a lot of information like that to demonstrate that certainly these defendants, Tennessee Gas and Southern Natural Gas, really did understand, contemporaneous with putting these lines in, what that erosion would happen if they didn't do certain things, and they knew what things they could do to try to stop that from happening, and that really bolstered our foreseeability position.
Well, and one thing I'll add is that I think we had a good argument that the defendants in that case actually had knowledge that it would cause erosion, but the standard was actually that a reasonable operator in the industry would know. And so we don't have to show that that particular defendant knew, just that the industry itself knew or should have known.
Can't leave Ollie hanging all night. Go ahead.
No, in brief, as I understand it, the Tennessee fight and that landowner action basically alleges what the state has recently alleged in another canal, the intercoastal. It's basically an erosion, you've gone beyond your permitted limits kind of case.
Correct.
I don't know that that's the gravamen of your case. I was just trying to distinguish. In your case, Dick, it seems to me that you're saying their coastal use guidelines themselves are violated. You're not arguing. They're arguing.
If you go to the paragraph 33, probably G or so, it says we allege no breach of contract claims, no tort claims.
No, I got that part. I guess
just the statutory claims.
I'd like to be specific about
Yeah.
exactly what violation of what reg are you claiming? What would be the clearest violation of the state reg?
Okay, failure, I'll give you one. Okay, 19.
Don't need the number.
719M.
No, okay. I'm trying to give you a year. Okay. In 1986, Louisiana passed a statute, adopted the amended 29B. It said you got to close all. We had like 20,000 pits open in Louisiana. You got to close all the pits.
Saltwater pits.
Saltwater pits. Okay. And it's almost on the heels of it. As soon as it happened, the issue came up is, do you need a coastal use permit to close a pit? Because if you go talk to the guys, the regulators, the people, I mean, as one of the people we consulted with, the first head of OCM, the general way of thinking is, if you got to turn dirt in the coastal zone, you need a permit, or you need to see if you, or you at least need to apply for one and have them tell you don't need it, okay? So there was a compromise reached, but it said that you have to get a coastal use permit to close a pit. Well, the statute says you get damages or other relief for violation of a permit that you did get, or for failure to get a coastal use permit when required. Okay? So because the law required you to close the pit, you were required to get a coastal use permit. You didn't get one when it was required. Therefore, we can sue for damages for you not getting that coastal use permit. That's one of the many theories, and it's a lot of it.
Damage would be limited to those pits.
Yes, but keep in mind, the regulation says, this is the argument anyway, the regulation says that in permitting, you have to take into account the cumulative impacts, and Woody has lots of, you know what I'm talking about. So once you got it in open water, once you go somewhere and everything's just open water, it used to be land. It's, and we've got experts, we have a team of experts at Rice that are working on all of the cumulative impact data and trying to relate it all.
When you say a compromise was reached, who reached that compromise?
So it was a compromise between, okay, so those of you like Lulin who really know the oil and gas law know that the Commission of Conservation is within the Department of Natural Resources, but they're basically separate agencies. And conservation is in natural resources only for staffing and financial reasons. So the Commissioner of Conservation and Jim Porter, this shows you how much it really had to be done. And Jim Porter wrote a letter saying, you need a coastal use permit. That's like, that would be like Rex Tillerson writing a letter saying, you need a coastal use permit. and so you need I think I'm pretty comfortable with those facts. So
I
anybody
think
else?
we're out of time, but is that right? Are we?
We are.
Thank you. Okay. Well, thank you guys very much.